Good evening. I'm Mary Hewson Callan, Director of Communication for the League of Women Voters of the Rochester metropolitan area. The League is a nonpartisan political organization which encourages the informed and active participation of citizens in government. We influence public policy through education and advocacy, and we focus significant effort on registering voters and encouraging them to get out and vote. If you, by the way, are not registered to vote, or if you've moved since the last election, please stop at our table in the entryway. Remember that the last day to register for the general election is this Friday, October 12th. By the way, the League is not limited to women. We welcome men joining us in making democracy work for all. All that said, welcome to our forum. The Supreme Court, distinct and independent. Our distinguished presenters are Richard C. Wesley, Senior U.S. Circuit Judge of the U.S. Court of Appeals for the Second Circuit. Also, Daan Braveman, J.D., President of our host here, Nazareth College of Rochester, former Dean of Syracuse University College of Law. Our moderator for the evening and the person responsible for bringing about this forum is Sarah Liebschutz, Distinguished Service Professor Emerita at the college at Brockport. Besides her invaluable contributions to the League, Sarah has been active throughout the Rochester community. She has chaired the board of directors for Rochester General Hospital, the Children's Agenda, and the Jewish Book Festival. She's published prolifically about government, politics, and healthcare. And after retiring from teaching at Brockport, at the college at Brockport for 27 years, in the political science and public administration departments, she returned to the U of R as an adjunct professor. I could go on. We request, however, that all of our guests respect our panel, our hosts here at Nazareth College, and our own commitment to civil and respectful discourse. It's now my great pleasure to introduce Sarah Liebschutz.
All right, can you hear me? Yes. Wonderful. The League likes to plan well in advance. When we began planning this forum, we had no idea what was going to be happening in the months ahead of us. But now, having all of us weathered the drama, political and emotional, this past week, around the appointment and subsequent confirmation of Brett Kavanaugh as Associate Justice of the Supreme Court, we turn tonight to consideration of the court as an institution. Almost exactly 221 years ago, on September 7th, 1787, the delegates to the Constitutional Convention in Philadelphia adopted and submitted to the states for ratification the federal Constitution, our founding framework to this very day. Separation of powers in the organization of the federal government is enshrined in the first three articles of the Constitution. Article 1 vests all legislative powers in the Congress of the United States, which consists of the Senate and the House of Representatives. Article 2 vests the executive power in a President of the United States of America. And among the provisions of Article 2, the one most pertinent for our discussion, the lead-off of our discussion tonight, is the President's power by and with the advice and consent of the Senate to appoint judges of the Supreme Court. Article 3, the judicial power of the United States is vested in one Supreme Court, and I'm quoting from the article, and in such inferior courts as the Congress may from time to time ordain and establish. Our forum tonight is titled The Supreme Court, Distinct and Independent. These are the words of Alexander Hamilton writing in the Federalist Papers published in 1787. Hamilton argued that, unlike in Great Britain, where the House of Lords at the time he was writing and to the present day is the final court of appeals, the Supreme Court in our country, its distinctiveness as an institution, that is to say, separate from the other branches, is essential, according to Hamilton, in a limited constitution. A limited constitution contains not only specific powers delegated to the Congress, Article 1, Section 8, but also exceptions and to this legislative authority, and they are in Article 1, Section 9. From Hamilton's perspective, powers both delegated to and denied to the Congress could be preserved in no other way except through the medium of the Supreme Court and federal lower courts, which include the courts of appeal and district courts. In Hamilton's view, the courts possessed only the capacity to render judgments. Crafting public policy and putting it into effect was entrusted to the Congress and the executive branch. To further preserve independent judgment of the justices, Hamilton argued for life tenure during good behavior of all federal court judges. At the same time, to avoid the potential for arbitrary discretion by the judges, Hamilton counseled that the court be bound by strict rules and precedent, which we know today and knew then as stare decisis, the decision stands. Finally, to assuage fears that the judiciary might override the powers of the executive and the Congress, Hamilton asserted that the, quote, judiciary from the nature of its functions will always be the least dangerous branch because it has no ability or resources to implement its own decisions. It has no influence either, in Hamilton's words, over the sword or the purse, because they are the provinces of the executive and legislative branches, respectively. Or, as Justice Elana Kagan put it recently in a talk just last week at Princeton University, we have neither an army nor a purse. What is critical is that we, the court, have legitimacy. According to contemporary historian Joseph Ellis, the last thing the 39 signers of the Constitution of 1787 wanted was for the Supreme Court to become supreme. They expected that status to belong to the Congress. The last location the framers wished to place sovereignty in the government they created, the last place was the Supreme Court, the most unrepresentative body and the one most removed from the wellspring of the ultimate authority in the people. Today, Ellis writes, the nomination and appointment process has become so transparently partisan and thoroughly politicized that no exalted image of the Supreme Court as a uniquely American version of the Oracle of Delphi is sustainable any longer. This evening, we have the great good fortune to have two outstanding individuals consider whether the court is still distinct and independent. Daan Braveman, to whom we are most grateful for this venue, is the 9th president of Nazareth College, now in his 14th year in that position. That's a long tenure for a college president. A Rochester native, he earned a bachelor's degree at the University of Rochester and a law degree from the University of Pennsylvania, after which he served as a law clerk to Justice Samuel Roberts of the Supreme Court of the state of Pennsylvania, and that is their highest court. Before coming to Nazareth, his last position was as dean of the Syracuse University College of Law from 1994 to 2002, where he had served as professor of law for the prior 17 years. His writings and his teaching during those years at the Law College focused on constitutional law, civil rights, and the federal courts, subjects certainly pertinent to our forum tonight. And also pertinent is the fact that President Braveman, as candidate in 2003 for Associate Judge of the highest court of our state, the Court of Appeals, has experience with a judicial confirmation process. Richard Wesley is a senior judge of the United States Court of Appeals for the Second Circuit. His court has jurisdiction over the states of Connecticut, Vermont, and New York. A Canandaigua native who grew up in Livonia, Judge Wesley earned a bachelor's degree at SUNY Albany and a law degree from Cornell University. After private law practice and then assistant counsel to the Republican Party in the state assembly, he was elected to 2 terms in the assembly. His judicial career took off with election to the state Supreme Court, that's the trial level in New York, in 1986, and subsequently with appointments to the appellate division, that's the intermediate division, and then to the state's highest court, the Court of Appeals, where he served for 6 years as associate judge. In 2003, Judge Wesley was nominated by President George W. Bush to the Second Circuit and confirmed, and listen closely, by the United States Senate by a vote of 96-0. Did you all hear that? He took senior status in 2016. But I must say, getting to know him, that seems to be a rank not at all equivalent to retirement. So please welcome our 2 speakers. Thank you. I want to say a word about the format tonight. President Braveman and Judge Wesley will spend about an hour in conversation, beginning with conversation around the appointment process and then moving through several other agreed-on topics and concluding with consideration of the court as the least dangerous branch. Then our speakers will be very happy to engage with you, the audience, and they and I look forward to your questions and their responses. So I'm going to move over here so I can try to moderate. So let us begin with your comments. This is on, you can help me.
No. I think it is.
Okay, right up here. With your comments about the confirmation process for Associate Justice of the United States Supreme Court. Who wants to lead off?
Well, I'll give you some background information about this. Since 1789, there have been 163 people nominated for the Supreme Court, including Justice Kavanaugh. Take a guess. Now, as Sarah pointed out, the process is the president nominates, but you need the advice and consent of the Senate. How many do you think were not approved by the Senate out of 163?
19.
11. There have only been, in the history of our country, only 11 nominations that were not approved. Now, there were another 20-some that were withdrawn. So basically, there was we saw a lot of discussion over the last week about whether the Senate will approve the nomination, give consent. But the fact is that historically, there have been very few instances when the Senate has not consented to a nomination. Some of you may remember the most recent ones, Justice Bork. Some of you may remember the name Judge Hainsworth. President Nixon nominated Judge Hainsworth. There was some concern about him because he had some support for segregation early in his life. There's also some concern that he may have had some financial conflicts when he was sitting on the bench. He lost. The Senate voted against him. Then Nixon appointed Carswell. And you may remember he was called Mr. Mediocre. He really had no experience. He too had some pro-segregation background. He lost. But over time, it's very rare that the appointment process doesn't lead to the appointment that the president wants.
Well, that's certainly true, and it's certainly also true that the process has been contentious in the past, and I do think there's a danger in defining, rendering it universal from the moment. And so these are contentious times in which we live. The nation has a troublement about it, I think, generally. In fact, as I was coming in, I was talking with one of the board members, and we were talking about the nation's psyche today. And I don't think the nation, I'm 69 years old now, and I don't recall the nation feeling as troubled, except perhaps maybe in my senior year of college when Kent State occurred and the burnings of the campus at Mississippi State and some of the troublements with regard to segregation and the violence in the South, in Philadelphia, Mississippi, and elsewhere. And so I do think that to some degree the confirmation process is to some degree a reflection of the national mood. Now, I'm not going to comment on the appropriateness or inappropriateness of anything that occurred in the last few weeks. From my own personal perspective, I've experienced this process now, both on a state and a federal level. And the process is extraordinarily probing. There's a document that all federal judges have to file called an SF-86. An SF-86 is necessary for a top secret national security clearance, and all federal judges have to clear and to receive an SF-86. I had to list every single place where I had lived and every single job I had had from the time I was 18 until the time of my nomination in 2003, and I was 54 years old at that time, so I had to reconstruct my life from 18. There were a few employers who I think were paying me on a cash basis. I had a little bit of trouble recalling my employment until I reminded them that the IRS code only required them to keep those records for 6 years, and so therefore there was no need for them to have records where work on their memories were remarkably rehabilitated. So it can be contentious. One thing I think that's important to keep in mind, I think people get frustrated sometimes when the senators ask of the nominee how a judge is going to view a particular case. You know, there were a number of cases about Roe v. Wade, a number of questions about other cases. And you hear the answer sometimes, it's now called the Ginsburg response. Well, Justice Ginsburg is a really smart person, and she's very up on the canons of judicial ethics, and so when she was nominated, she gave what is, quite frankly, the appropriate response. Judges are not, pursuant to the canons of judicial ethics, not to express an opinion with regard to any matter that may come before them. Why is the reason for that? The reason for that is that you don't buy judges, at least hopefully you don't, and judges are supposed to keep a free and open mind. Now that frustrates a lot of people because, quite frankly, some people don't want them to have an open mind. They want to know exactly how they're going to rule on something, and that's just not the case. I can understand the frustration with regard to that, and there's certain, I think at times people have a sense that that's disingenuous to some degree. But think of it if it were the other way, and if there were a promise made through a particular way. What legitimacy would that ruling have in your mind? None. And if there's a lesson that I would hope to drive home tonight, is that I think that the rule of law is the thing that has kept us together. there's a great book that you'll probably hear me mention at least 3 times tonight. John Meacham has a book called The Soul of America. It's a terrific book. It shouldn't give us solace, but Meacham explores a number of occasions during our national experience where we haven't necessarily been the best of the nation that we could be. The second rising of the Klan in the 1920s, when members of the United States Senate were openly members of the Ku Klux Klan, where 11 states had governors that were openly members of the Ku Klux Klan. Think of that nation. And what kept us together was the rule of law, and the cornerstone to rule of law is an independent judiciary. And the cornerstone to an independent judiciary is the belief that judges will do things without favor or prejudice. And part of that judicial independence is a commitment to consider matters that come before you without prejudging those matters in any way. And so the Ginsburg response is an appropriate response, frustrating many times for folks in that regard. And I understand that the most recent round doesn't really turn on, the controversies don't turn on necessarily those responses. I think the Ginsburg response has become accepted. And I don't give it the title of the Ginsburg response to belittle it in the slightest. I think it's terrific, because Ruth Bader Ginsburg is my circuit justice, and so she's the judge that I regularly have to deal with. She gets the first crack at anything I've done, and but well thought out in my mind.
I think one of the confusions for the general public is we want a Supreme Court, or all federal judges, but we're now talking about the Supreme Court, to be politically independent. So that's why we give them life tenure. You might wonder, what a great job. You're there for life. The only way you can remove a Supreme Court judge is he or she retires, dies, or gets impeached. In the history of our country, there was one Supreme Court justice, Samuel Chase, in 1805, where the House voted to impeach him, but the Senate did not convict him. So we have never removed a Supreme Court justice through impeachment. So all that talk you heard last week about, well, we'll impeach him, forget it. It's not going to happen. The frustration is we want a politically independent federal court and Supreme Court, and yet we see how political the process is that produces that. So how is it that we have appointments that are the product of a political process, and in this last go-round, a very intense political process, which is different from the 3 judges I mentioned who did not get it, Hainsworth, Carswell, and Bork. There, it was very interesting. The votes were Republican-Democrat on all sides. There were a number of Republicans who voted against the Republican nominee, the president's nominee, who was the Republican Party. So the issue becomes, once you put the robe on, does the judge lose all of that political baggage that produced his appointment? I think that's one of the confusions that people have to struggle with. And we have seen instances where judges have, in fact, changed politically, and probably the best is Earl Warren. I mean, Eisenhower once said that the worst thing he ever did was appoint Earl Warren, who was a conservative Republican from California, to the Supreme Court of the United States. But I think that's one of the things that the public is wondering about. How does a justice come through this process and then put on the robe, and now all that political stuff disappears?
Judge Wesley, when we talked before this evening, you talked about your own confirmation,
right,
the hearings and such. Now, you are a Republican,
yeah,
and you've always been, you're well known to be Republican, and yet the 2 senators from New York who shepherded you through this process were both Democrats. You want to talk a little bit about that?
Yeah, Hillary Clinton and Chuck Schumer were the 2 senators at the time, and I had voted for and sponsored the death penalty as a state legislator a number of times, and of course both of them held contrary views on that and other public policy matters. But what was very fortunate for me on a number of levels was a number of people had gotten to know me in my judging work that were close to both senators. And one of the very influential people was Judith Kay, who was the chief judge of the New York Court of Appeals, who I'd served with for 6 years. And Judge Kay and Senator Clinton were extraordinarily close. And Judge Kay spent a good deal of time with Senator Clinton talking with her about me. And I also knew Senator Schumer, who had also served in the legislature, but had left the legislature a few years before me. And I knew several people in his counsel's office. I also had the great benefit of having been appointed to the appellate division by Mario Cuomo. Mario Cuomo was an extraordinary governor in the context of judicial appointments. He had a very formalized review process, and headed up by former members of the New York Court of Appeals. And so when I came to, when my name was under review for the appellate division, Cuomo went with the recommendation of that committee, which was had both Republicans and Democrats on it. And so by having been nominated by a Democrat to an intermediate appellate court, that altered, I think, the calculus. I spent a great deal of time with Senator Schumer and with Senator Clinton prior to the actual confirmation. We spent a lot of time talking about my background, but curiously, no one, not in my interview with Alberto Gonzales, the very first interview I had at the White House when they asked me to come to Washington to be considered for the Second Circuit, not at the White House counsel's office, not at the Department of Justice. There was a fellow at the Department of Justice by the name of Yet Bin, who headed up the Office of Legal Policy, which is the arm of the Department of Justice that screens judges. That wing right now happens to be headed up by a woman by the name of Beth Williams, who clerked for me. And not at any time that I spent with Senator Schumer or Senator Clinton did anyone ask me about a particular case or how I would rule on a particular result. They did ask me about cases that I had ruled on, and what the underpinning of that ruling was, and asked for explanations about that, and that would be totally appropriate to discuss something that you had ruled on. But I think it says something about the process that there was not an expectation, neither at the New York Court of Appeals or at the federal level, with regard to asking about a particular result. When I was preparing for the interview at the White House, because I spent some time with people who worked in the Bush 41 White House for that interview, I was shocked when they said they're not going to ask you about a case, and so they did.
President Braveman, you were giving us a wonderful segue into the topic of judges and judging. So how about talk a little bit more about that?
So the question is, once you get through this political process and you put on that robe, have you now lost your political perspective and all your perspectives that you came to the court with? And we heard a lot over the last few weeks about judges as umpires, right? Judge is an umpire, all I do is call balls and strikes. Well, this is my favorite month of the year for sports. I love October. I was sick about last night, but one thing, anybody who knows baseball knows that different umpires have different strike zones. Not all umpires call the same pitches balls and strikes. Some have wider strike zones, some have narrower strike zones, and we call it judging, which means people are exercising judgment. I mean, we're not just taking the facts of a case, feeding it into a computer, giving them all the prior cases and asking the computer what the result is. We could do that, but that's not what we do. We now ask people to exercise judgment. And when people exercise judgment, they bring to the decision-making process their perspectives, their experiences, and that's why you get 9 justices who look at the same facts, they read all the same cases, but they may come out differently from each other. So, I hear this umpire thing so much, and I really hope that judges, we have a judge here, so we can ask him, but I hope they don't put on a face mask and a a chest protector and call balls and strikes. That's why you have that little box when people, you know, when they're pitching, you can actually see whether he called a strike correctly. So judges, judging involves judgment, and judgment means that people bring their perspective. And would a Judge Kavanaugh have a different perspective than Judge Garland, who did not get the job? My guess is he would. Now, that doesn't mean it's inappropriate, but it does matter. I think that's I think what we saw was an attempt to say, all of my background, good, bad, and indifferent, doesn't matter. But one thing I learned from clerking for a judge is judges are people just like the rest of us, and they bring their experiences, their life experiences, and their perspectives to the process. So I don't know, are you an umpire?
Well, I think there are some obvious balls and obvious strikes.
Those cases don't make it to the Supreme Court.
Well, that's true, but they sure as hell make it to my court. And what I was going to say is that I think the vast majority of cases that the intermediate appellate courts see fit within the standard deviation. And so there's really not a lot of debate among panel members about what is the right result. There actually is a right result upon which people don't disagree. And that right result is not a function of a particular philosophical viewpoint in life. I have a really good friend, Rosemary Pooler, over in Syracuse. And Rosemary is a little farther left of center in the world of political philosophy than I am. But Rosemary and I don't disagree that often. Guido Calabresi may be the most liberal member of my court. I have now been a member of the Second Circuit for over 15 years, and I've never been on a panel with Guido, a three-judge panel in which I've descended from Guido or Guido's descended from me. Guido mentions it all the time. I don't mention it all the time. There's one other thing that I do want to mention. On the day after Bush v. Gore was decided, Stephen Breyer went back to his chambers and discovered that his law clerks were just beside themselves, and had thought, the law clerks really thought that the court had really undone itself, that the court had really was beginning now, and it was going to disassemble, because his clerks in essence thought that the decision was so, in their view, patently wrong and patently political, that it was going to drag the court into the political abyss and cause the court to go unglued. Breyer rebuked them. Breyer said to them, you have to appreciate the fact that everybody operates under good faith. These are firmly held views, but they're not disingenuous views. They are honest views. They're different from the views that you have, but they're views that have legitimacy in the context of the support that they draw from the Constitution. Maybe they shouldn't carry the day, but they were generated in good faith. And I think that sustained Breyer. And people ask me sometimes, what happens when you have somebody who writes a really kind of pointed dissent against you? You appreciate the fact that those are honestly held views, and you accept those views. You don't have to necessarily agree with them, and you accept the fact that people can look at things differently. Let me give you one, I want to give you a takeaway on this. I want to give you a concrete example. So I'm going to give you a citation, especially for the students that are here so they can establish that they were actually here. The name of the case is Zarda versus Altitude Express. 883 Federal 3rd 100, decided by the Second Circuit after following en banc review this year, 2018. The question in Zarda was, does Title VII of the United States Code dealing with discrimination in employment, where you cannot discriminate based on sex, does that protect an individual who's discriminated against because of his or her sexual orientation, because they're a homosexual? What's curious about this is that the Title VII was enacted in 1964 and used the term sex. It did not use sexual orientation. And there were 3 judges that argued there There is absolutely no way that Congress was attempting then to protect people who had a different sexual orientation from being discriminated against during in employment. Those three judges happened to have been Jerry Lynch, Deborah Livingston, and Rena Raji. Well, Jerry Lynch, if Guido Calabresi is the most liberal judge of the court, Jerry Lynch is the second most liberal member of the court, and Deborah Livingston is the most conservative member of the court. And if you then look at, there are 9 separate opinions written in this case by 9 different judges with 9 different reasons why the result should be that Zarda did have a claim under Title VII for discrimination. And among them was Dennis Jacobs, a founder of the Federalist Society, also happened to be the author of the Windsor decision at the Second Circuit, which was a precursor to Oberfeld. And so I bring this to your attention to show you that it's not so easy always to predict where someone will come out because of their viewpoints. These are honestly held disagreements about what Congress had in its mind in 1964, and judges just simply trying to work it out. And it dissolved philosophical orientations with regard to folks. And I think it's a very interesting example of how judges really do take a look at things and they simply come out differently on things at times.
Just to continue this conversation on judges and judging, as you review cases, both of you, can you ever think of a case where a judge who seemed to be consistently conservative changed an opinion and voted in a way that was unexpected? About Scalia. Scalia in a case involving, I don't know if it was a drinking age law or something like that. You don't recall it? Okay. Can you think of one, Daan?
Before I do that, you used the word that is very interesting to me. You said a conservative judge came out a different way. And I think that's another topic that needs to be addressed. We use these phrases, a liberal judge and a conservative judge. And my sense from studying this and teaching this for a lot of decades is that those meanings have changed over time. So there was a time, and Frankfurter's probably the best example of this, there's a time when a conservative judge was a judge who said, my job is not to second guess the political process. You know, we can't vote judges out of office if we don't like the Supreme Court decisions. We can vote legislators out if we don't like what they do. And so we have a system where we defer to the political process as a conservative judge. And the only time a judge would step in is in the rare instance where the political process might have infringed on the rights of minority groups who don't have access to the political process, or have interfered with fundamental rights. But basically a Frankfurter conservative would say, doesn't matter what my politics are, I'm going to defer to Congress in the elected branches of government. That's what we used to know as a conservative judge. I think today it's taken on much more of a political meaning. That a conservative judge is someone who is politically conservative, and a liberal judge is someone who has liberal political bent. Now that doesn't mean they don't come out, as Judge Wesley said, in some instances in an unpredictable fashion. But if you take a Justice Scalia, who everyone thinks is a judicial conservative, and look at some of the things he's done, it's actually, in the old-fashioned way, quite liberal. He had no problems declaring acts of Congress unconstitutional when he disagreed with what they were doing. Now, we'll talk later about original intent and originalism and how he couched it in, well, what our framers thought they were doing. But he was not a Frankfurter conservative. He was not someone who necessarily said, let the political process work, and we're only going to step in the rare instance when the political process is somehow suspicious. So I think the meaning of conservative and political and liberal has changed over time.
Yeah, I had to get my feet underneath me. I can think of two.
Okay.
One is Scalia, and that is with regard to the confrontation cases where previously in federal court you could submit an affidavit that was done with regard to a test or another device, an out-of-court statement that then was offered for the proof of its content in court. And there's a series of confrontation clause cases that Scalia wrote where he reverses position and took a very defendant-friendly, frankly, position, very libertarian kind of viewpoint with regard to that, saying, look, if you can't cross-examine, if it's offered in the sense of, and that it's testimonial in nature, it was prepared in the context of expecting that it was going to be used in a criminal proceeding, then that violates the confrontation clause. So there is clearly an example where Scalia changed his position. But a more telling one, I think, is with regard to Chief Justice Rehnquist. Chief Justice Rehnquist was a constant critic of Miranda. From the time he came onto the court, throughout the period, a long period of time when he was Chief Justice. And then late in his tenure as Chief Justice, a case called Dickerson, I think is the name of the case. I'm not really good with the names of cases, but I think it's Dickerson. Came up to the court, and came out of the Fourth Circuit out of Richmond. And everyone thought it was the perfect vehicle to overturn Miranda.
Does everyone know what Miranda means?
Miranda, I mean, you have all seen it on Hawaii 5-0 or CIS or, whatever the current cop show is, you have the right to remain silent, etc., etc. And Rehnquist, writing for the court, says, no, we're not going to overturn Miranda because it's the settled expectations of how people understand how to behave. It's too ingrained into society, and it's too much a part of the fabric of law enforcement. And so therefore, whatever complaints I may have had about Miranda, Miranda remains the law of the land. And I think that's very telling in terms of Rehnquist's own jurisprudence, because Rehnquist was very pointed in his criticism of Miranda, and yet when confronted with the prospect of actually following through and understanding the implications, he had to weigh the value of stare decisis, the value of the settled expectations that the law had been settled, versus, being proven correct after 15 years or 20 years of complaining about it. And I think he chose stability. Now the question becomes, and I'm not going to answer the question that's going to be generated by opening this door, but what will Roberts do? What will Roberts do in some of the watershed cases that you all have in the back of your minds right now, with now a conservative, with what's viewed as a quote conservative majority on the court? Who knows? I'm not certain that we can be certain. And so, but the Chief Judge, Rehnquist's example, I think, is a very telling example of the reverence that some of the justices on the Supreme Court hold for stare decisis.
So I think in my mind, the most famous example of where a judge switches a vote occurred during the Depression. So what happened during the Depression is Congress kept passing laws trying to deal with fair labor, minimum wages, and they had a Supreme Court that was very conservative from an economic standpoint. Believed in laissez-faire, the government should interfere with the economics of business. And so these laws were passed, and the Supreme Court kept declaring them unconstitutional, and Roosevelt wasn't able to get his plan through to deal with the Depression. And you will remember, some of you remember your history, that's when he said, okay, why don't we change the size of the court? There's nothing in the Constitution that requires 9 judges, at times we've had 6. So he said, well, go up to 15, and as these old guys die off, we'll go back to 9. And so he had this court packing plan, which was not ever enacted, but what happened is one of the 5 judges, because all those cases that were striking down these laws were 5-4, with the conservative, economic conservatives in the majority. One of them, Justice Roberts, switched his vote on a key case so that the law was upheld. And that's this famous, the switch in time that saved 9. That's where it comes from. That Roberts switched his vote, and that saved the Supreme Court as 9. So that is probably historically one of the most famous moments where a judge who consistently was voting to strike down these laws switched his vote in order to save the court as an institution, which is probably pretty important to save the court as an institution.
You mentioned before the concept of originalism. I want to talk about that a little bit. Do we know what that means? No.
So, originalism means that you interpret the Constitution by either, there are 2 versions of originalism. One is that you interpret it by what the framers meant when they wrote the words. Justice Scalia's version of originalism is you interpret it by what the practices were at the time the provisions were enacted. And it has a surface appeal, because one of the things we should be concerned about is that when you put people up there, give them life tenure, and they're politically insulated, we should be concerned that they're going to just vote their own feelings. I mean, there's, you know, I call this the Heartland cereal test. What'd you have for breakfast? And that's the way I'm going to vote. Well, we should be concerned about that because we didn't put any of these judges there to explicitly vote their own feelings or preference. And so one way to control, say, the originalists, is to tell the judge, what you do is you look at what the framers meant or what the practices were at the time, and that's what governs today. Now, I don't know, I hope we have a debate here. In my mind, there are so many things wrong with that. One is trying to figure out what the framers intended. There weren't good records, and in addition to the people who wrote the Constitution, we had to have state legislators and legislatures approve them, the provisions of the Constitution. How do we know what they intended when the documents were ratified? Whether it's the original documents or the amendments after the Civil War. So one, it's very hard to figure out. But 2, and there's a famous Yale law professor by the name of Alexander Bickel, and he had this wonderful phrase. He said, "No answer the wrong question begets." No answer the wrong question begets. He says, the question isn't, did the framers intend what was going on then to be governing us 200 years later? Did they contemplate that things might change? And I'll give you an example that someone used, and I forgot who it was, but I think it's a great example. When your little child or grandchild goes to daycare, you tell your kid, you know, treat the other children nice, you know, nicely. And you have in mind certain things, right? Don't bite them, don't steal their crayons, don't steal their toys. But something will come up that you didn't think about, but you still want them governed by the concept of nice. And the problem with originalism, in my mind, is that it focuses on the conception rather than the concept. It focuses on what was actually the practice at the time, which is, in my comparison, don't bite, don't steal the toys, and, you know, whatever. And it confuses that with the concept. So take the phrase equal protection. It's sort of a vague concept. What do we mean by equal protection? The 14th Amendment says, no state shall deny equal protection. Well, when they adopted that, they had no conception of the fact that there might be public schools someday. And that these public schools may or may not be segregated. It just wasn't in their thinking. And if they thought about it, at the time of that we ratified the 14th Amendment, they probably would have thought, sure, at the moment we have segregation. But that doesn't mean that the framers meant that in 1954 we should be bound by that conception. And I think the most difficult thing for Scalia to have explained when he was alive is how he would have decided Brown versus Board of Education, which is the school that held separate but equal schools are unconstitutional. Because if you go to an originalism view, you would have to come out the other way. Because there's no way that the people who adopted the 14th Amendment thought that they were authorizing desegregation of public schools, which didn't exist. And so this originalism is a problem because it locks us into the conception that our framers may have had 200 years ago or 150 years ago, and doesn't give the possibility that what our framers really wanted was to preserve the concepts, which change over time. The last thing I'll say about this is, think about the Fourth Amendment. The Fourth Amendment prohibits unreasonable searches and seizures, right? Now, when that was adopted in the late 1700s, they didn't have devices that could look into your bedroom from the sky. They didn't have GPS, right, that they could attach to your car, or they didn't have cell phones and they could follow you wherever you go. So what does that mean? Does that mean the Fourth Amendment does not require a warrant before the state or federal government searches and searches you or follows you using your cell phone? Well, if you ask the framers, they would look at you like you're crazy. They have no idea what you're talking about. But the concept of what we were trying to preserve in the Fourth Amendment can be adopted to current realities. And so my problem with originalism is that it locks us into practices that existed 200 years ago, and it doesn't leave room for the possibility that the framers actually wanted the Constitution to be preserved over time. One of the most beautiful things about our Constitution, amazing things, is how long it's lasted. Just think about it. There are very few countries that have a Constitution that has lasted this long with so few amendments. And the reason it is because, and Scalia will turn over in his grave when he wouldn't listen to me, but if he heard that we have a living Constitution that changes over time.
You know, for a college president, it gets pretty worked up. I feel like I'm back down at Holy Square listening to oral argument. I'm not certain that I agree with Daan completely. Originalism doesn't work, and the conservative wing, the Scalia school on originalism, doesn't even pretend that it works on some of the constitutional issues that the court looked at. To take, for example, the Eighth Amendment's cruel and unusual punishments clause and the court's application of the cruel and unusual punishments clause to the death penalty in the United States. Roper versus Illinois, I think it is, says that juveniles can't be given the death penalty. And the standard is not who got death back at the founding, because a lot of folks got death at the founding. For a broad array of crimes, the cruel and unusual punishments clause arose out of the concern that the framers had with regard to the fact that the royal courts under the Stuart kings were punishing people for unbelievably minor things. But the standard under the Eighth Amendment is an evolving standard of decency. So it has nothing to do with originalism whatsoever. And so originalism really doesn't mean anything in an Eighth Amendment context. It's an evolving standard because, good Lord, we don't kill people anymore for stealing a loaf of bread. And thank God that we don't. And we don't put people to death anymore for rape, which we once did. And so rape's no longer a crime for which the death penalty can be given. I also don't think that it works very well, and Daan's pointed it out, in the context where you have technological advances that go way beyond what the originalist kind of understanding was. And originalism really, in that context, I think, is really kind of searching for core values that the framers thought were important and then trying to distill them out. The devil is always in the details. And so the originalists are always able to find a set of materials that speak of one thing versus the other. Originalism with regard to Fourth Amendment jurisprudence is very libertarian, very protective of individual privacy. And so a lot of folks who would not think of themselves as conservative would be very happy with a lot of the stuff that the originalists have come through with regard to Fourth Amendment jurisprudence. The most problematic area for me as a judge is understanding originalism in the Second Amendment, and this is where the rubber will meet the road into the future. Now, I won't prognosticate as to where the Second Amendment jurisprudence is going on because it can't prevent me, but I will talk to you about a case called Kuchelski. Kuchelski was written by me several years ago, and the question is New York's handgun licensing scheme constitutional? The answer of the court was yes. At the Second Circuit, and cert was denied. Cert has been denied regularly by the United States Supreme Court, and Thomas has been complaining about it in Second Amendment cases since the case out of Chicago, the handgun case out of Chicago, and the handgun case out of D.C. And the big question is, where will the court go into the future? The problem with the Second Amendment is, it's hard as hell to figure out what it means. And in an originalist context, New York was regulating firearms before the founding. New York City had firearms regulation before the founding. And so it's very hard to say from an originalist standpoint that, you know, it was like this big frontier kind of thing going on, and everybody was packing. You know? They were packing long rifles is what they were packing. And the standard that's emerged from the first two decisions is this kind of weird standard that says, what is the weapon of choice? Whoa. Now, I'm from Livonia. I guarantee you the weapon of choice in Livonia is a hell of a lot different than it is in Brighton. You know, I was raised with rifles and handguns. So I think that the Second Amendment is probably where originalism is going to have a real battle. I will say one thing, and then, because I see that I'm concerned about time and I want to leave time for questions. Daan's touched on something that also reaches into statutory interpretation. Having served in the state legislature, to accept and our reliance upon language and the court's reliance on language, and this goes back to that sexual orientation of sex case that I mentioned to you, trying to figure out what the words mean. To say that the legislature is of one mind about any particular thing, or that they even know, for example, all of the language that's contained within the statute is Pollyannish. I mean, it's just crazy. I once wrote an article called "The Legislature Should Fail, Who's to Follow?" in which I did a panel discussion with two leaders, one from the Senate, one from the Assembly, and they said, you know, if we can't agree to something, we put in ambiguous language and we'll let the court figure it out. Well, think about it. Isn't that the most perfect political solution? Because if the court agrees with you, brilliant, brilliant. The court did brilliant. And if the court doesn't agree with you, it's those activist goddamn judges. You know. So, and what's curious about it, and I'll end it here. The court ends up being the arbitrator. The legislature accepts the legitimacy of the court in resolving that dispute, and maybe that's a good thing. Maybe that's a good thing. Maybe that's what does produce the compromises within legislative bodies, the reliance upon the court to ultimately untangle some of the yarn that they tangle in the legislative process.
Well, I think we have one more topic to consider, and that is, what recourse does the public have to unpopular decisions? And with respect to that, is the court the least dangerous branch? So, can you address each of those, and Daan as well?
Well, we went through 25 or 30 years of absolute resistance to Brown versus Board of Education in the South. If you, when I was an undergraduate at Albany, I became very interested in pre-Civil War South and the African American experience in the South. And so I read the Richmond newspapers the day after Brown versus Board of Education was passed, and it referred to the Black Republican Supreme Court demands desegregation. A lot of public schools closed in the South rather than integrate. Can you imagine that? I mean, we forget about that. Our minds forget about what occurred. I have a picture in my chambers that was taken in 1968 as I was headed to Fort Lauderdale, Florida with 3 of my fraternity brothers from Albany. We were just interested in getting to Fort Lauderdale and drinking as much beer as humanly possible. That's all right, I've been confirmed, don't worry. And I'm too old for anything else, so I've got just life tenures out on the horizon. Right? Outside of Jericho, North Carolina, on old US 1, I-95 was not completed, but just outside of Jericho, North Carolina was the following billboard. Welcome to Jericho, North Carolina. You are in the heart of Klan country. Join the United Klans of North Carolina. Help stamp out integration and, quote, communism, end of quote. Okay? And a picture of a Klansman riding on a horse draped in white, holding a burning cross. I keep that picture in my office so that my law clerks see the America that I grew up in. Because it's important for them to understand the America that we grew up in. Okay? But there was extraordinary resistance to Brown, and federal courts all over the country. Frank Johnson had his house bombed in northern Alabama because he was ordering desegregation of the Alabama schools, the Alabama prisons, and the Alabama universities. And so there has been enormous resistance to judicial decisions in the past. But what could you do? What could you do, or what could others do to decisions that you think are equally repugnant? The Roosevelt administration continued to pass laws and frankly threatened the Supreme Court in a way that was which was constitutionally appropriate. There is no set number of justices. There have been instances where the Supreme Court had 7 justices and not 9 in our history. And so there is precedent with regard to that. We can pass legislation. Some things we can do on a state level sometimes. I sat in the state legislature as a sophomore in 1970 when a fellow from Auburn by the name of Lee Michaels stood up and changed his vote and made abortion legal in New York, 4 years before Roe v. Wade. There was never any litigation about abortion in New York because abortion was legal 4 years before the Supreme Court found a constitutional right for a woman to control her own health care decisions up through the 3rd trimester of pregnancy. And so there are some things. That's little solace to someone in Texas with regard to the Roe issue. And I'm not offering it that as it. But there are state-based solutions many times that could resolve those matters.
Okay, you've got the last word.
Well, that scares me. I think, you know, that there are a variety of things that we the people can do if we don't like what the Supreme Court is doing. Judge Wesley mentioned one that we saw after Brown. It's you ignore the court. You just don't comply. So you have, you know, pictures of Governor Faubus standing in front of schools to prevent kids from desegregating the schools. And this is where the least dangerous branch comes in. Because the Supreme Court does not have the power of the purse or the sword, there's nothing it could do itself. So it had to rely on first Eisenhower in the case of Arkansas, and then Kennedy in the case of Ole Miss to bring out the troops. If either one of them had just said, you know what, some of you may remember the famous quote after the Cherokee Indian case where it was said, Justice Marshall made the decision, let him enforce it. So one possibility is you can just ignore what they're doing. And fortunately, the constitutional crises we've had have been resolved where the political branches have stepped forward in most instances. Another thing you can do is continued litigation. If you look at, Roe, which generated so much opposition, the court has not overruled Roe v. Wade. But what's happened is there has been continuous litigation chipping away at the extent of the right to choose. So legislators would pass laws restricting pieces of the right, and that would go up and the court would uphold it. The best example of that is separate but equal. So in 1896, you have the Supreme Court holding that separate but equal is constitutional, and in the 1920s, the NAACP adopted a strategy. They are going to deal with that doctrine. But they didn't bring Brown right away. What they did is they chipped away. So they brought lawsuits arguing that school districts were separate but not equal. And they kept winning those. And they had actually a written strategy to overrule Plessy versus Ferguson. And eventually they got to Brown versus Board. So another way you deal with the court where you don't like its decisions is you keep litigating, and over time new judges appear on the court. That's probably one of the most effective ways to deal with a court if you don't like it, is replace the judges at some point. They either retire or they pass away. But I just wanted, the last thing I want to say is something, to underscore something Judge Wesley said, because I think this is what's going to happen for people who are on the, quote, liberal side, if we're going to use that term. There is going to be much more resort to state courts to protect rights that the federal courts are no longer protecting. In some states, it's great. In New York State, it's probably great. I don't know what it is in other states. But I think if I'm, as a lawyer, if a client comes to me today and wants to challenge something, an invasion of civil liberties, I would look very long and hard at even picking a federal court. Because something we didn't talk about is that what's happening in the federal system, again, this is depending on what your political perspective is the lower courts, which have a great deal of influence, they are being changed as well in terms of who's being appointed. Certainly different judges are being appointed today than under the Obama administration. And the Supreme Court hears 80 cases a year. Your court hears thousands.
4,000.
And that's just one. And then there are district courts that hear hundreds of thousands. So a lot of law is being made in the courts at the lower level. And the last thing I'll say is the power of the Supreme Court. The power of the Supreme Court lies in its legitimacy. The reason we comply with even decisions we don't like is because we consider the court a legitimate court. It's not because they can bring out the troops to enforce their opinions. They can't raise money to enforce their opinions. It's because we consider it a legitimate institution. And the worry is if the court loses its legitimacy, it loses its authority, its power. And the court knows it. And probably the best check on the Supreme Court are self-imposed restraints so that it doesn't lose its own legitimacy. And they have all kinds of ways of restraining themselves, and they have, and that's what they do to protect their own legitimacy.
I would also say that you should be watching Chief Justice Roberts, because I think the case can be made that he is at this point in time anyway, the single member of the court in whose hands and in whose writing and whose decision-making rests the legitimacy of the court as an institution. So I would watch what he does. Now, we have time for a few questions. If you have one, please stand up. Please stand up and raise it.
I'm going to challenge you to get off of the Supreme Court, because most of us here are not going to deal with cases of tremendous constitutional issues. But we very well may have to deal with local state court judges. And I know, Judge, you were elected as a state judge. I'm concerned, frankly, about the amount of money and influence that local politicians have with people who are running for state judicial office. People here might not realize that for the most part, except for the Court of Appeals, all the judges in New York are elected officials. And they have to run up with a political party, and they have to sometimes solicit a lot of money from lawyers that are not so willing to part with their dollars, but do part with their dollars because the next day they may be in front of that judge.
Well, I'm asked that regularly, because I've been both appointed and elected. The trial bench, I was elected in '86. I think both appointed and elected systems are capable of producing great judges and also really bad judges. The difference is, I think, is generally in the context of accountability. And what do I mean by that? I think where the numbers in a district are relatively in play, such that a Democrat's capable of being elected in a district or a Republican's capable of being elected in a district, the incentives on the political leaders are much stronger to run someone able. Now, we'll get to the money in a second. And so the question of, are there able candidates being put forth? And in my view, generally where you have, where either party is capable of winning the election, that's true. When the numbers go the other way, like say for example, a Republican is not going to be elected in Manhattan to Manhattan Supreme Court. Okay, that's just not going to happen. The appointed process doesn't necessarily also produce really qualified judges in Manhattan either. Many of those judges, some people might characterize as politically beholden to other people. And so, is it patronage, or is it a function of money? The money is trouble. The money gets very difficult in states where you elect high court judges. The money gets astronomical and it can disintegrate the court. It ruined the Wisconsin Supreme Court a few years ago. Just tore that court apart. I'm not so certain here. I mean, I ran in 1986. John Parnell was in the audience tonight, and John tried, what, John, 3 or 4 cases in front of me. I have no idea whether John gave me a dime or not. It didn't really matter to me. What mattered to me was John prepared. He always was. He always was. And I always enjoyed having him in my courtroom. I think there is potential that if the contribution levels were high, that there would be a discomfort level that people might begin to feel, and so that would be a good argument to keep them low. I think it's also good that judges have a sense of accountability to the people that they serve. I don't mean in terms of result, I mean in terms of availability and getting their work done. And so I thought that the electoral process engendered in me the idea that I had a responsibility to the people I was serving. I did not have the sense that I owed anybody a favor, but then again, it was not a situation. I raised a lot of money. I had to, because I was from Livingston County, and this is a Monroe County, Rochester dominated media market. And Livingston County is 60,000 people. Monroe County is 11.5 times the size of Livingston County. So for me to even get the nomination was not an easy matter. But I don't think that it necessarily, I can appreciate the frustration about it, and I can appreciate that if the contribution levels are high, then you begin to have a problem. But I'm not necessarily convinced that there's a quid pro quo going on, especially where there's political accountability among the parties. One last thing about that, though. New York has something that's very important. It has a Judicial Conduct Commission. Now, I know, and you all know full well, because it's had something to do, and you're going to see a result in the next week or so. Because the Court of Appeals is meeting on the 10th and the 11th. It meets tomorrow and the day after. And I suspect the decisions will start to come out of the Court of Appeals in the last round of arguments. So there may very well be a decision of interest to all of you with regard to a judge's fate in the Monroe County area from the arguments that were heard just a month ago in Albany. That Judicial Conduct Commission is an extraordinary check on judicial misconduct, and is well run and well financed by the governor and by the chief judge to do its job, which is to keep an eye on judges and hold judges accountable, because no judge, no person is above the law.
Do we have about 2 more questions here?
I have a question about the tenure on the Supreme Court. You mentioned it was Alexander Hamilton, I believe, who decided life term.
Well, he didn't decide it, he supported it.
Supported it.
He advocated it.
At
Yeah.
that time, lifespan was like 60. And in light of today's life expectancy in the 80s, and it's been proposed, some people have been saying 18 years, 20 years. What is your thoughts about that?
Can you repeat the question? We can't hear you.
Yes, the question has to do with life tenure. And when 200 plus years ago it was advocated and it's enshrined in the Constitution, life expectancy was much, much lower than it is now. And there have been proposals for term limits, but the one I'm most familiar with, and which you mentioned, is 18 years. So, do you gentlemen have a view on that?
Well, I do.
No?
I feel like a young 69, so life tenure still feels pretty good. There have been folks who have criticized that there ought to be at least some process by which mental acuity is recertified or examined. We have that process in New York. The age is 70. And New York judges, at least state Supreme Court judges, can certify for 2-year periods. They have to undergo a very rigorous physical to show that they're physically capable of continuing to perform that. And I think that probably would be something that should be thought about in the federal system. But what's interesting is that when you start to talk about something like that in the federal system, federal judges go berserk. And they start talking about separation of powers. And because they're terrified that Congress is going to interfere with the free and independent judiciary. And so they talk about that. Well, then the question becomes, maybe the judges themselves ought to regulate. And there are some processes within the federal judiciary where reports of disability can be made, and then there is a process by which a judge could be examined and determined to not be fit. Thurgood Marshall was in very tough shape when he ultimately left the United States Supreme Court. And Justice McReynolds, who was a virulent anti-Semite, would not be in the same room with Benjamin Cardozo when Cardozo was on the Supreme Court, was crazy. And there was no way to get him off the court, and ultimately he died, and left the court and then died shortly thereafter. But in fact, there's a book that I was trying to search in my mind. Joe Bellicosa used to talk to me about this book. There's a book about judicial incompetence on the federal judiciary side. Personally, I have 2 law clerks that I trust deeply, whose job is to come and see me at the time that my mental acuity is at a point where I'm no longer able to do my job. And every year that I have new clerks, I talk to them about the prospect that they might have to have that conversation someday.
I think if I understood the question as well, part of it had to do with removing judges who are no longer competent. But I think what I heard was the question, well, why not every so often just get rid of a judge just so you can get whether the person is competent or incompetent, just so you can get new people on the court. Is that what you're wondering about? Why we don't limit and say you get 10 years on the Supreme Court and then we're going to appoint someone else? The reason we give life tenure is because of this independence notion. Now, I guess you could argue if you just say you get 1 term of 10 years, we don't have to worry about that as much as if it's a reappointment process. Clearly, if it's a reappointment process, then we have to worry about our judges going to do things that are politically acceptable to the people appointing. It's a good question. My sense is that the longevity of a justice is a good thing for the country, and that we don't turn over the court every 10 years, because it gets back to this legitimacy issue. That, you want judges on the Supreme Court who have a sense of history, a sense of, what's been decided before. And if it becomes a 10-year job, and then I'm moving on to something else, is there a perception that the person is deciding cases so they get the next job and whatever? I think it would compromise the independence of the judiciary.
And think if you had that rule right now, Ginsburg and Breyer would be off, and the current administration, well, a prior administration, perhaps a Republican administration, would have appointed their successor.
Okay, I think we have time for one more question. You got back there.
If I could, yeah.
All right, and then you, all right, you go.
Oh, I'm sorry. So I think it's interesting, you know, when we talk about, and I'm glad you brought this up, that the real question for advice and consent, although it's not specified in Article 2, should be qualifications. And you seem to bring that up, that it should be an apolitical job. And interesting enough, you know, we talk about tenure. The UK has 20-year limits, but also in the UK what they do is when an opening comes up, the Chief Justice brings in representatives from every country in the UK, Wales, Scotland, and England, and they get together and actually meet in private and then come up with a recommendation to the Prime Minister and the Crown. So what really seemed to be happening here in Kavanaugh, the Kavanaugh case, was a politicalization of the process. If you look at his record on paper, when he and Merrick Garland were together on the DC Circuit Court, that they agreed 93% of the time in their decisions. In fact, I think it was like 28 out of 30, Kavanaugh agreed with Garland when he was writing decisions, and 27 out of 28 times when Garland joined Kavanaugh. So it transcended qualifications. And there were Democratic senators who were coming out against Kavanaugh before his name was even announced. There were organizations, NGOs, or nonprofits, I should say, that were against Kavanaugh that actually came out with press releases and his name wasn't there. So what I'm concerned about, and again, you know, Jason Brennan brings us up in Against Democracy, and if we read the opening to the Constitutional Convention, Hamilton and others argue, he says, look, the reason we have to have a federal government is because there's too much democracy. Has too much democracy entered the selection process, the advise and consent? And what do we do about the politicalization of the nomination process?
Well, until somebody finds a way to suspend the First Amendment, I don't think you're going to do much about it. I mean, I'm not trying to be polite about it. I apologize if I seem that way. This disappointment was destined to be the eye of an incredible storm because of the key role that Justice Kennedy played in the Roberts Court over the last 10 years. I mean, Kennedy was the swing vote, and so it's not like what Judge Gorsuch's opinion or nomination was like, because that was just filling up an existing conservative slot, you know. And so this had all the makings of a perfect storm for it, and I don't know how you could avoid it. And it's just that's going to happen. It's going to happen in a free society that I mean, liberty has its costs. You know, that's why that Meacham book is so, I don't know if you've read it, but the Meacham book is so compelling in so many ways. I mean, we have the liberty to be stupid and to be ignorant and to be incredibly prejudiced. I live in the town where I was born and raised, and I'm regularly trying to explain to folks why it isn't always the way they think it is, or they feel it is. It's not always easy, but I would be very concerned about somehow trying to create a situation that tried to fix this problem. I hate to define the means by the extreme, the media by the extreme, and I think it's dangerous to do it in this instance.
You have the last question.
A couple of observations. One is, you can't separate the hearings that just took place from the political environment that exists outside. So this isn't an isolation. We are now a very politically divided country. This nomination, which was critical to the balance of the Supreme Court, took place in that context. The fact that Garland and Kavanaugh voted similarly in 95% of the cases, all it does is confirm what Judge Wesley said before. Most cases that come to the courts of appeals are relatively easy cases. And the difference is that while Judge Wesley is bound by what the Supreme Court decides, a Supreme Court justice can overrule what they previously decided. So that's what was at stake here. And it isn't the first time we've had a political dispute over an appointment. The first justice not to be approved, and the first nominee not to be approved by the Senate, was a nomination by President George Washington. He nominated Rutledge to be on the Supreme Court, John Rutledge. And John Rutledge, after he was nominated, came out and said, if George Washington is going to sign the Jay Treaty with Britain, he's an idiot and he should be dead. And he ended up not getting confirmed by the Senate. Go figure. So this is not the first, I mean, we've had political issues throughout, but I really don't think we can separate what happened last week from the political environment we're living in.
Thank you. This is sort of a pointed question. I don't mean to sound too old or insult younger people in the room, but as a physician scientist, we find many of us feel that the scientific education of the country has fallen down, and that's what is responsible for a lot of ills of vaccine hesitancy or anti-evolution or anti-science in general. And some people I've read that some people feel the same about journalism, that we don't have Walter Cronkite anymore, we don't have Eric Severide anymore, people who either doctors or journalists who we felt had the legitimacy that you're saying that we need in the Supreme Court. And I would posit that many of us feel our politicians have fallen, that we don't have Kennedys anymore, we don't have Roosevelts or even Eisenhowers or whatever stripe you want. What are the law schools, since I'm not a lawyer and I don't know anything about the law, what is the legal education system doing now to realize that the country may be changing in an anti-intellectual fashion that may end up with, I think the legal profession is still sort of virginal as far as I can tell, but sure hasn't happened in politics, journalism, or science. So what are our legal minds thinking of this as a challenge to how we educate the future and pull ourselves back from such a political morass?
I thought the dean would answer.
He's teaching currently at law school.
That's true too.
I'm always nervous about reveling in the glorious old past. The billboard outside Jericho, North Carolina, certainly keeps reminding me of that. And foolishness in politics is not something recently invented. Bigotry in the media. Well, Father Coughlin had his broadcasts, which were virulently anti-Jewish during Roosevelt's administration. And so there has been this ugly underside to the American experience long before of late. It's just that we seem to have caught a dose of it recently. And there may be reasons to understand that. On the education side,
I would
go ahead.
I've been out of the law school now for 13 years, so I don't know what law schools are. But I can tell you, I think this is an issue for higher education generally, not just law schools. It's an issue for our college, and that is, how do we disagree and do it in a civil manner? I mean, I think that my concern is, and people who are maybe from the faculty or staff here hear me say this all the time. I think one of the most important things we can be doing in higher education is getting our students to learn how to live and work across lines of difference, whether it's ethnic, racial, religious, intellectual differences, political differences. The world isn't any more different today than it was when I was young 100 years ago. But because of technology, we're aware of day in and day out. We live what one writer calls the ever-presence of difference. And if we don't, in higher education, get our students to start thinking about how you can celebrate that difference and understand it and talk across it, if we don't do it, then we're just sending out more students into the world to just repeat what seems to be going on now. The lack of civility is what disturbs me the most. Putting aside whatever your politics are, but the inability of people, the inability of you, some of you in the room, and me, to talk to friends because we disagree strongly is a real challenge. And I think, and so what are we doing? We are trying to do things at the college here to get students to walk across lines of difference. And I'll give you just one example. We had a very unfortunate incident here a week and a half ago where something nasty was posted on a board. We have no idea who did it. We'll probably never know. But 2 days later, we held a meeting of students to discuss this. We had 175 students show up on a Monday night to talk about this issue of bias and hate. And you know, some student said to me at that meeting, he said, you know, why are we letting this incident, this nasty thing, define us? And I said, that is not what's defining us. What's defining us is that there were 175 people here who wanted to talk about this and try to understand it and get beyond it. And I think if we don't do this in higher education, it's not going to get done because we're getting kids who come from high schools where everybody is like them. If you look at, we talked about Brown a lot today. High schools and public schools are more segregated than ever.
Yeah, you know, the three most segregated schools in the east are Rochester, Buffalo, and Syracuse.
So your question is a great one, but I would not limit it to law schools. I think colleges like Nazareth.
I agree. It's just you were from a law school and I wasn't.
Yeah.
So
it's been years. I'm a recovering lawyer.
This has been a marvelous evening, an evening of civility, a decrease of hyper-partisanship, which is really what is characterizing the country now. And I know that we are all very grateful to Judge Richard Wesley and President Daan Braveman. Thank you very much.
On behalf of the League of Women Voters, thank you so much for joining us this evening and participating in this important discussion. We're so grateful to our excellent presenters, Judge Richard Wesley and President Daan Braveman, and of course our moderator, Sarah Liebschutz. You'll find information about the League of Women Voters on the table as you leave, and of course if you're not registered or have moved, you know. Please be sure that you've left your email address with us, as we'll probably have some summary information that you may be able to use assisting you in future advocacy efforts. And a recording of this evening's presentation will be posted on our website, along with information on future forums, including our next forum, which will be November 19th, when Dr. Timothy Neeland of Nazareth will present a commentary on next month's midterm elections. One more note, Judge Wesley will be speaking on judicial independence in a digital age at MCC on October 11th. Once again, thank you so much for attending this evening.